Yes, Mr. Rosie.
My Lords, I'll move on now to the second part of ground 3, which, as I indicated, relates to the figure that was allowed by Mr. Pillinger in his schedule for contractors' overheads and profit. And for your reference, we see that in the table that I took you to that summarises Mr. Pillinger's figures, page 238 in the supplemental bundle. Now, when a quantity surveyor is placing up a scheme of works, it's conventional to make an allowance of this sort. There may be a variation in the percentage, but that is the convention when performing the sort of exercise that Mr. Pillinger was performing. In the context of the respondent's determination, the purpose of getting this information from Mr. Pillinger was to provide inputs for Mr. Jones's residual valuation. But in the, as I've said a number of times, in the context of adjusting the Bloxham Road comparable transaction, the object of the exercise is to compare like for like. So the valuer and therefore the court in performing this exercise should only net down the gross price for the subject site by equivalent costs which are packaged into the £13 million paid for Bloxham Road. And the information that we have on the abnormal costs for Bloxham Road is contained in the Savills email that I took your lordships to earlier. They are the figures for abnormal development costs, and they are broad, rounded figures. And the appellant's case before the judge was that they are not figures which include a 12% or any other percentage for overheads, profit and such like, and therefore that head of cost, when netting down the subject site, should not have been deducted from the headline gross value that Mr. Jones arrived at. The evidence in support of that was given in Mr. Fort's report. I'm not going to take you to the passages because of time, but for your reference, it's paragraphs 9.9 and 7.23 on pages 123 and 130. And that was reiterated by Mr. Davies in paragraph 6.8 at page 221. Now, Mr. Buckingham, in his cross-examination, was rather coy, if I can put it that way, and I'll take you to the passage in a moment, about what the Savills figures, what those rounded figures would have comprised and whether they would have included this additional quantity surveyor's line that one would get in a detailed schedule of costs. Essentially, what Mr. Buckingham said in cross-examination was, I can't know. I can't know whether or not it's included. And the submission to the judge was that, given the nature of the rounded figures that were provided in those emails, they can't have condescended to the level of detail that we see, that we get from Mr. Pillinger in the report that he prepared for the defendant in our case. And therefore, the argument was that it is, and based on the evidence of Mr. Fort and Mr. Davies, it is inappropriate to net down in respect of this 12% line for both abnormals and, if, contrary to our case, there is any netting down for enhancements, for the enhancements as well. The figures should be the construction cost figures only, without this additional 12% uplift. Now, the judge just didn't deal with this point at all in his judgment. although he dealt with enhancements in a broad brush way in the passage that I took the court to before the adjournment, this issue goes beyond the treatment of enhancements. It applies to the abnormal costs too. In the schedule on page 238, the figure that should have been deducted for abnormal costs was 730,000, not 818,000. And if there's to be any deduction for enhancements, it should have been 939,000, not 1,052,000. And so that, in effect, takes over £200,000 of value off the subject site in a way that we say wasn't supported by the evidence before the judge. And as I've indicated, the judge simply didn't deal with this issue. And we argue in this appeal that the judge was wrong not to deal with it. And he ought to have dealt with it in the way that I've just outlined. So, my lords, I come then to ground 7, which raises a small, but we say important, crucially important point about the court's valuation of the site based on the expert evidence before the court. And again, I recognise that in this ground of appeal, I'm asking the court to reverse the judge on a question of fact or expert evidence. And here the submission is that the judge failed to deal with comparable evidence, which he had accepted to be taken into account in the valuation. So, one thing that was common ground between the parties at trial was that a valuation based on comparable transactions should take precedence over a residual valuation, which goes so far as to say is common sense. Real life arm's length transactions demonstrate what the market was doing on the valuation date. This ground of appeal focuses on the choice of relevant comparables. Mr. Fort and Mr. Davies, for the appellant, referred to 14 comparable sites that transacted around the valuation date, which they said were relevant comparable evidence for the purposes of determining the value of the subject site.
I mean, it's 14 sites which they say were comparable.
Yes.
I mean, the question is, were they comparable?
Indeed. Their evidence was that those 14 were sufficiently comparable to affect or to take into account in assessing the value of the subject site. Yeah. The defendant, in his determination, considered that there was only one relevant comparable transaction to take into account, and that's Bloxham Road that I've referred to. Bloxham Road sold 10 months after the valuation date, but there was no suggestion on this side that it couldn't be taken into account for that reason. And indeed, we didn't suggest that there was any other reason not to take it into account at all. What we disputed was, first of all, how the comparison exercise was undertaken, and secondly, and relevantly for this ground of appeal, the fact that all of the other comparables were completely left out of account. Now, having heard the evidence when the judge came to his conclusions on this aspect of the valuation, there were 2 sites out of the basket of comparable evidence that was before the court that the judge accepted, based on Mr. Buckingham's evidence, ought to be taken into account, which weren't then reflected by the judge when he performed his valuation. And those 2 sites are located in a village called Adderbury, and the sites are called Milton Road and Ayno Road. These were two sites with planning permission for development. They were within approximately 2 miles of the subject site, and they were both sold within a year and a half of the valuation date. Mr. Jones's evidence as to why he didn't take those two into account was that he said he didn't find them remotely comparable because they were, as he put it, village sites, and he considered that that was a reason to have no regard to them at all. And the judge heard evidence from Mr. Buckingham for the respondent and from Mr. Davies for the appellant on this, and he dealt with this issue at paragraphs 219 to 227 to 29. In particular, it's 228 and 229. At paragraph 228, the judge referred to the evidence of Mr. Buckingham that in producing a valuation for the site, he ought to have looked further at these Atterbury transactions rather than focusing, as he did in his report for the court, solely on Bloxham Road. The judge said at the end of line 4 in 228, however, it is necessary to have regard to the fact that Mr. Buckingham accepted under cross-examination that he would not have focused entirely on the one comparator, albeit recognising that Bloxham Road represented a very helpful comparator, and that he would also have looked further than Mr. Jones had done at Ano Road and Milton Road, which Mr. Jones had not had regard to. And then at 229, the judge went on to consider what he should do with that finding. And he said, I consider it's then necessary to consider whether doing so would have led Mr. Jones to a significantly different result. Nobody has in fact carried out a comparison exercise as between the subject site and Ano Road or Milton Road on a pounds per plot basis that distinguishes, as I consider that any comparison exercise ought to do, between market units and affordable housing units, and also adjusts the village location of the latter. Consequently, I have no proper evidential basis for coming to the conclusion that a comparison exercise so conducted would have demonstrated Mr. Jones's exercise, carried out solely by reference to Bloxham Road, produced anything but a robust valuation of the site, etc. So, in effect, what the judge was saying was that none of the experts had carried out a comparison exercise that takes these two comparables out of the basket and adopts the method that the judge has accepted is the correct method of comparison and puts all of that into a calculator or a computer and produces a number for the judge. And on that basis, he said he had no evidential basis for coming to any different conclusion. Now, we say that is wrong. That is a misdirection, in effect. Because what the judge is doing there is relegating the judge's role when determining an issue of valuation to choosing between competing values advanced by the respective experts, which is precisely what the Court of Appeal made clear in the Capita case that the court shouldn't do. The judge has referred to the extract from Capita at paragraph 47, I think it is, of his judgment. It's page 228 in the authorities bundle, if your lordships want to refer to it there.
Sorry, I'm not sure I'm following this argument. Is it right that in valuing or the comparative values of Enyo Road or Milton Road adjusted for the village location of those, the fact that those two other sites were a village location?
There is not a figure before the court as to an adjustment for village location, but all of the other data is there, as I will demonstrate in a moment.
But the judge has accepted earlier that that's an important feature of having reference to comparables. You've got to, if you're trying to compare a village site with a non-village site, you've got to make an adjustment. So he's saying,
indeed, but that's
he's saying that's important, but nobody did it.
Well, that's not a mathematical judgment. That's an evaluative judgment as to.
Well, it's for an expert, in fact.
Well, if the judge has evidence and accepts the evidence that there are relevant comparable sites that sold for X, and the judge accepts evidence that X is too high as a value for the subject site because of locational factors, the judge is required, we say, based on all of the evidence he's heard of the relative values of the two sites and the locational factors that he's heard evidence about, to determine what that adjustment ought to be.
On what evidential basis?
Well, on the basis that the value of the subject site is going to be lower than the value of those two sites, and it is for the judge to form a view on the basis of the comparison as to how much lower it ought to be.
But he did form a view. He formed a view that he had no proper evidential basis for coming to the conclusion that a comparison exercise would have demonstrated that Mr. Jones's exercise was anything but robust, or that it was out of tone, or that it was out of skew.
Well,
in 3 paragraphs he said, I've looked at this and there's no evidential basis that I can find that shows that this adds up to a row of beans, to put it bluntly. I mean, how can you challenge that on appeal? It's a factual appeal. You're asking us to redo it.
Well, what the judge has said that is missing is the sort of analysis that he had for Bloxham Road in relation to Ano Road. And he had all of the data in Mr. Jones's report.
It looks as if he's looked at it. And it looks as if he'd said, and I looked at it and I've come to the conclusion there isn't enough in there to say that it's out of skew. So he's done the exercise and come to the conclusion it doesn't add up to anything.
Well,
he's not saying I'm ignoring it completely. He's saying I've looked at it and the evidence doesn't add up to a row of beans.
Well, my lord, it's probably a matter of interpretation of what the judge has said. But we say that what he's done is he hasn't taken that evidence into account.
Okay.
But I mean, he's right, is he? I don't think you said he isn't. That there was no evidence in front of him which took those comparables for Ano Road and Milton Road and adjusted their sale values to distinguish between market units and affordable housing units.
No, there was evidence, and I can show you.
In relation to those two sites?
Yes. And it was in Mr. Jones's report.
So, but your ground of appeal doesn't say that was an error for the judge. He ignored actual evidence on the point, does it? Or does it? I mean, if it does, well, it may be. The court ought to have taken account of the undisputed evidence of the value of the sites at Ano Road and Milton Road. So there was common ground as to what adjustments should have been made for market units and affordable housing units, and also for adjustment of the village location and not village location in relation to those two units.
Yes, it was unchallenged evidence. It was in Mr. Jones's schedule. It's in 2 places. First of all, there is an appendix to Mr. Jones's schedule at tab 9 in the supplemental bundle at page 75. and you'll see that the Bloxham Road adjustments are highlighted, and to the right of that,
so this is Mr. Jones.
This is Mr. Jones. The equivalent figures for Ano Road are set out, which, when adjusted for date, come to a value of £181,000 per plot. And the equivalent for Milton Road didn't find its way into his final schedule, but it was contained in a draft of this document, which is at page 269.
So 269.
269, yes. So there's a column headed Milton Road, Adderbury. And the only thing that that draft schedule, which was undated, doesn't do is adjust the bottom line figure for date. But that's a mathematical calculation based on the index that is appended to his determination. And as a matter of mathematics, that takes the adjusted plot value of Milton Road to 168,792. So the judge had those gross market plot figures before him for these two sites.
Well, he says he does.
I beg your pardon?
He says he does.
Yes.
227.
231.
I mean, what I don't understand is how you can get over the words, on a proper analysis, they don't lend support to a valuation significantly in excess of Mr. Jones's valuation. So he's done an exercise, he's looked at it, and he says several times they're not out of tone, they're not out of skew, they don't give any, because of the differences, I can't get out of this a difference. I mean, this is just a pure factual appeal. You say you should have gone your way.
Well, my lord, I'm conscious that I'm trespassing on my learned friend's time. But we emphasise the second sentence of paragraph 229, where he says that nobody has carried out this comparison exercise.
Well, it goes on.
Because
It goes on to say it's the whole of that sentence. That's his rationale, isn't it?
Because it ought to also adjust for a village location.
well, that's where we say he's misdirected himself. That is an adjustment that it was open to the judge to make himself, and he has just declined to engage with the exercise. That's the point we make.
How much adjustment? How much do you want us to do if you think he didn't do something? You say he didn't do something he should have done.
Yes.
So presumably you want us to do it.
Well,
so where do we get the knowledge to do it from?
well, we say that if all that is before the court are the figures.
Okay, well, where on those 2 pages do I get to know how much of an adjustment to make to Ainio Road to take into account the fact that it's in a village as opposed to the subject site, which is somewhere else? How do I know? Just, I mean, others may know, but I don't. I mean, I can't see how to do it.
There are 2 ways of proceeding on the back of this. Either your lordship takes a broad brush approach and effectively splits the difference between those sites, which is not just a sort of finger in the air approach. It is a recognition of the fact that there should be some adjustment, and in the absence of further evidence, that is the best the court can do, and the court is told, it's directed, that it is to do the best it can with the evidence.
Well, no, just with respect, it's not the best the court can do, because normally the court relies on the experts in front of it, and none of them did it. That's the point he's making. There's no expert evidence of the task that you say he should have done, or that we could now do. I mean, that's right. There's just no expert evidence that suggests how that should be done.
The only other evidence there is recorded by the judge at paragraph 56. (56.5) on page 87. Where the judge says that he refers to Mr. Buckingham's evidence that properties in Atterbury sell for £100,000 more than those on the site. Now, I mean, assuming in the respondent's favour that evidence is accepted, the judge has information in Mr. Buckingham's report of the sale prices of properties on the site. And one way of a more scientific, as it were, approach to this is to work out what percentage uplift that £100,000 average would be on the sale prices of the properties on the site, and then to use that as a baseline to compare with the adjusted values.
Did the closing submissions or anything else give that sort of calculation to the judge?
No, that wasn't.
We'd like you to do this, please, or you should be doing this.
No, that wasn't advanced to the judge as a way of doing it, because this wasn't one of the numerous avenues that was, on this side at least, that the court was being asked to go down in terms of...
It's a bit harsh to criticise a judge for not doing something which nobody in fact asked him to do.
Well, I recognise, of course, your lordship's point, but...
I think we may be running into the buffers with this point. I think we've got the argument that he should have done that, and we'll have to decide in our...
Very well. I mean, the only final point I make is the alternative way of dealing with it, if your lordships accept that the judge should have engaged with it but didn't, if this court isn't able to undertake that process, is remission.
Send it back.
Yes.
Yeah.
Well, your lordship has
Said with a straight face. Very good. Now, does my lord have a point? Yes.
I do. Could I just ask, I have an authority which I'd like just to, can I just ask please that those, hello? Sorry, could you just give those to counsel? Could we just go back in the authorities bundle to Mr. Justice Coulson in tab 3 in KS Lincoln? And at the bottom of page 86 in KS Lincoln, this is on ground 2, margin of error, and your proposition is that this is something the court should fix. It's not a matter on which experts should express a view, right? Yeah. So at the bottom of page 86 of the authorities bundle, Mr. Justice Coulson says the starting point is Singer and Friedlander and Mr. Justice Tasker Watkins, and then he sets out a quote. Now, in fact, the reference that is wrong, it's not 1997 to the States Gazette Law Reports, it's 1977.
Yes.
And I've just handed to you the report. In fact, it's not from the Escapes Gazette, but it is the same report. And the quote that Mr. Justice Coulson sets out there is to be found at page 74. But what's interesting, and I'd really like your observations on this, is what Mr. Justice Coulson has excised from the quote. Because it says the permissible margin of error is said to be generally 10%, When you in fact go and look at the authority, and it's page 74, it actually says the permissible margin of error is said by Mr. Dean and agreed by Mr. Ross to be generally 10% either side of a figure which can be said to be the right figure, i.e. so I am informed, not a figure which later with hindsight proves to be right, but which at the time of valuation is the figure which a competent, careful and experienced valuer arrives at after making all the necessary inquiries and paying proper regard to the then state of the market. In exceptional circumstances, the permissible margin, they say, could be extended to about 15% or a little more either way. Now, the they, Mr. Dean and Mr. Ross, are the expert, Mr. Dean, You see that from paragraph 609 at page 78, who is a defendant, qualified, experienced Mr. Deal, a partner in the firm of Savills, etc., etc. And as it turns out, Mr. Ross is actually the person employed by the defendants who actually did the valuation. And you see that from page 73. So that the foundation for Mr. Justice Coulson's formulation seems to be based upon Mr. Justice Tasker Watkins' quote, which he based upon two experts and didn't just determine himself. That's what I would like you to comment on, if you may, because it seems to me to negate your submission that this is just something the court should do for itself, and it's not just based on expert evidence.
Well,
you may want some time to think about that. I've just landed you with that on your feet, but it did appear to me that the foundation for all this is expert evidence.
very well. I'll accede to that offer, if I may. I'll give it some consideration while my learned friend's on his feet.
No, thank you.
Thank you very much,
Thank you.
Mr. Rosenthal. Mr. Chapman.
My Lords, before starting my submission, just while we're on the point that my Lord Justice Snowden has raised, I'll come on to give the references, but in fact we will see that in Cares Lincoln itself and Webb, and indeed Dunfermline, there was expert evidence that went to the percentage range as well. So this is not just a feature that's unique to the decision of Mr. Justice Tasker Watkins in Singer and Friedlander, but actually in the other cases to which my learned friend has taken, my Lord, there was expert evidence going to percentage as well as difficulty. But I'll come to that if I may, but I wanted to make that point while it was, so to speak, fresh in all of our minds. My Lords, as you know, in short, we say this appeal falls to be dismissed because the judge was right for the reasons he gave. I will come to the first ground of appeal rather more swiftly than I had originally planned to, because I know, or at least apprehend it's of interest to my Lords. But my Lords will also understand that our starting point is somewhat different to my learned friend. Our starting point is that this is overarchingly and at heart an appeal against the judge's findings of fact. While ground one challenges the judge's application of the Boland test and therefore gives rise to an argument as to the law, it is accepted, quite rightly and fairly by my learned friend, that ground one is not engaged unless and until he has succeeded on one of his other grounds of appeal. See, for example, the appellant's skeleton argument at paragraphs 46, tab 3, page 28, and paragraph 83, tab 3, page 38. The remaining grounds of appeal, upon which my learned friend has to first succeed, grounds 2, 3 and 7, are clearly, and we would say, clearly confined to challenges to the judge's findings of fact. As to that, we say, first of all, that is an unpromising starting point. At worst, the fact that with respect the appellant then fails to engage, at least seriously, with the relevant and stringent test before this court will interfere and disturb a trial judge's findings of fact is, with respect, fatal to this appeal. Now, my Lords, we have in our skeleton argument at paragraphs 12 to 17 in the core bundle tab 4, page 44, set out the well-known principles relating to appeals against findings of fact. I won't take my Lord to those now. The key passages are those in Volpe at paragraphs 2 to 5 and 65 to 66, Authorities Bundle tab 10, page 403 and 411, and Mr. Justice Lewison, Lord Justice Lewison, as he'd then become in Farge, at paragraph 114, Authorities Bundle tab 7, page 326, where the learned Lord Justice refers in particular to the dangers of island hopping, which with respect, my Lords, is exactly what the appellant is seeking to do in this case, hopping from one piece of evidence, one finding to another, without paying due regard to the overall findings made by the judge on all of the evidence at trial. There was perhaps just one further authority I should take my Lords to, and one I should give a reference to, which is how findings of fact on appeals in valuation cases have been addressed by this court. And that is mentioned and addressed in Capita which is at bundle, the authorities bundle tab 5, page 228. And this is in the judgment of Lord Justice Gross. Gross, I'm so sorry. And one sees in dealing with the approach to be brought to bear on valuation appeals, I'll have to come back to this for other purposes later, but at paragraph 43, Roman 2, one sees that having dealt with Singer and Friedlander and Range, the learned Lord Justice ends that paragraph by saying the very nature of valuation and the inherent imprecision in the exercise underline the intensely factual nature of this issue, and for my part a reluctance to interfere with the judge's conclusion unless driven to do so. And to like effect, at paragraph 82, at page 239, in the judgment of Lord Justice Moore-Bick, concurring with Lord Justice Gross, one sees the conclusion, third line from the end. In those circumstances, I think that this court should be slow to reject the judge's finding on a matter of this kind, i.e. finding of fact. And for my own part, I'm not persuaded that it would be right to do so. And to like effect, we need not turn it up, but in Titan, this court again, tab 8 of the authorities bundle, page 351, paragraph 24, Lord Justice Longmore refers to the hesitancy in reversing findings of fact, again in a evaluation context. And with respect, in our submission, the appellant...
Could you just give me that reference again?
I'm so sorry, Lord. It's tab 8, page 351, and it's paragraph 24, where the learned Lord Justice says, if we were reversing the judge on a question of fact, we would, of course, be extremely hesitant about doing so. But in that case, what the court was being asked to do was effectively overturn inferential conclusions from the findings. So all to like effect, and all, so to speak, relatively unsurprising given the overarching guidance on appeals against findings of fact. And with respect, we say there is nothing here, and the appellant has not identified anything here, which would drive this court, to use the language from Capita, to overcome its reluctance, which would otherwise exist, to interfere with the judge's findings.
I mean, the court, you're less worried about interfering with what might be called an evaluative judgment based upon evidence. I mean, this isn't a question of the judge seeing witnesses of who's telling the truth and who's lying.
That's fair enough.
So, I mean, it's not a finding of fact in the most traditional of senses.
But my Lord, I would accept that. But nevertheless, as we see from Capita and from Titan, which are both cases concerned with challenges to findings of fact in a valuation case, the hesitancy is still there, albeit it may not be, to pick up the Lord's point, as marked if it was simply based on...
Well, I mean, the judge had days of evidence. I don't know how many days, but it sounds like quite a lot of days, and got into all the valuation evidence and the schedules and the figures and the per plot and the abnormals and the where it was. We haven't got a plan, we haven't seen the site, we haven't got a clue what it's all about or where it is. And, you know, we are not in the same position as the judge. And so to say he got it wrong on the facts in this very quite long, I normally say very lengthy, which is taken as a term of abuse, and I don't mean it like that, but it's a lengthy, careful judgment. To say he gets it wrong in a lengthy, careful judgment by picking out, island hopping, literally picking out nitpicking points, is something this court is not very happy to do unless there's something glaring about it. And for my part anyway, the glaring bit, if there is any glaring, is on the percentages. And if Mr. Rosenthal is right about the percentages, which obviously we know you say he isn't, but if he were, and the judge did say that Jones got it wrong in material respects, therefore if he's wrong about the percentages, if he's right, you're wrong about the percentages, then that's something we might consider interfering with. Which is why, I regret to say, we'd like to hear you on the law. Because the law does seem to me, speaking only for myself, to have been, what should we say, glossed over in the past.
Well, my lord, can I move then to ground one on the law and,
Yes.
and see if I can
That
provide...
would make me happy at least, because I think it's quite interesting as well. I mean, not that not we care about the law in this court, but it is disappointing to read a number of authorities which all say there's a logical fallacy and don't cure the logical fallacy.
Well, my lord, if I may say so, we understand that.
Yeah.
Although I now feel somewhat the weight of expectation. But let me see if I can discharge.
You've been here before, Mr. Chapman. Last week, wasn't it? Or the week before?
It was, my lord. Now, can I begin with what the essential complaint is, as we understand it, about what the judge did? Because one has to start with what the complaint is about what the judge did and what the judge, in fact, himself did, as we say it was, before then moving on to more general considerations about the law, which I know is where my lords are interested.
Well, except that if we look at the judge's judgment on the law, it does sort of slightly fizzle out a bit, doesn't it? I've forgotten the paragraph number. You can tell me 160, is it?
Yeah, well, it certainly starts at 160, and there's 165, which I'll come to. But one has to at least look at the case that we have to meet first of all, and then I'll come to the judgment present, if I may. The way that the matter is put in my learned friend's skeleton, and it may be just worth turning that up, which is in the main core bundle at tab 3, at page 27.
Which paragraph of his skeleton is it?
It's paragraph 43 and then 45. So 43 is the complaint that, having identified the principles set out by Mr. Justice Eder in Capita, the judge did not apply those principles in his judgment.
Sorry, 43.
Paragraph 43.
42 and 43.
42 and 43. So there's the first complaint. The judge did not apply the principles set out in Capita. And then the real essence of the complaint is to be found over the page at paragraph 45.
Yes.
Last sentence. On the basis of the above authorities, in particular the decision of the Court of Appeal in Merivale, all that a claimant has to prove is that the valuation was outside of a reasonable bracket. Now, just pausing there and going to, if I may, Dunfermline.
But just to be clear, I mean, I put that to Mr. Rosenthal, and he said that's not quite the way he puts it. He doesn't. I think he accepted very fairly that he wasn't actually putting it quite as high as that last sentence, paragraph 45.
And really, this is a submission really by way of clearing the decks, because that's how it was put in the skeleton. The point I was going to make is the same submission was made, curiously you might think, although one understands the reasons for it on the facts of that case, by counsel for the defendant valuers in Dunfermline, in very similar terms, and was rejected by the court, in Dunfermline, relying on Capita, which itself relies on.
This is the point between sub 3 and sub 5, sub 7 of Capita.
Yes.
Judge Klein rejects that very point. Which paragraph can you just tell us? In
It is Judge Klein in paragraphs 32 to 35 of Dunfermline, which is authorities bundled tab 9, and it's at page 364. So, my lords, will see at paragraph 32, counsel for the defendant, valuer Miss Day, making effectively the same submission as my learned friend does to my lords in this case. And the judge then at 33 saying he does not think that's the correct approach, and instead agreeing with leading counsel for the claimant in that case, Mr. Cannon, and then referring to Mr. Justice Eda's principles, 7 principles in Capita.
Yeah.
And
it was Miss Day who made that submission, and he says that's wrong.
Yes, and then at 35, whilst it is clear from Capita that to succeed in a professional negligence claim against a valuer, a claimant must establish not only that the valuer's valuation fell outside the range of valuations which a reasonably competent valuer could reach, that is the bracket, as I shall describe it in this judgment, but also that the valuer fell some way below the standards to be expected of a reasonably competent professional. Because Miss Day accepted on CBRE, that's the defendant's behalf, that in this case, if CBRE's valuation of the property was outside the bracket, it would follow that CBRE was negligent and that DBS would be entitled to judgment on liability. That is how I intend to proceed. So he identifies the position as a matter of principle, but as it happens, because of the
She agreed, and didn't matter. The only thing he had to decide was what the proper figure was, which he did.
Exactly. Now, so as I say, that addresses and in our submission disposes of the way in which my learned friend puts the argument in his skeleton argument. And is the short answer to the way that the appeal is put in writing, at least.
Have you got a proposition which you're going to come to as to what the test is?
I have, my lord, but it might be helpful first just to look at what the judge did.
And to keep us waiting. That's all right. Let's look at the judge.
Well, it may be the proposition is not far away from 162 in the judgment.
Well, my lord's as always at the head of me, but there will need to be some explanation and rationalisation, which I'll seek to add to that in an attempt to explain why the judge was right to apply what my lord the Master of Rolls described as the well-embedded principles coming from Merivale, and perhaps giving some indication of how this submission, I hope, will develop. The principles are well established or well embedded and have been applied. Their explanation in their application has not always been what it might have been.
No, and it's really 166 I find a bit difficult, particularly 1662. I'm not sure I understand it precisely, but anyway.
Well, is it perhaps helpful to turn up then what the judge said at tab 7, page 108?
Yeah.
So the judge starts by identifying Capita, and at 163 highlights the passages with which we're now very familiar from Merivale.
Yes.
Before saying at 164, we would say correctly, the fact that reference is made to a condition or precondition that the valuation should fall outside the margin itself demonstrates to me that the identification of the margin or bracket cannot itself be determinative of the bounds of reasonable professional competence, at least unless the process of determining the margin itself involves such an exercise. And he then paraphrases what was said by Mr. Justice Dove in Barclays Bank and TBS, and identifies 4 principles which he then directs himself to apply. So the first is the court must form its own view based on the evidence and its own evaluation the correct value is at the valuation date, applying professional practice standards which applied at that date. And I suspect there's no dispute about that.
Yeah.
2, having formed its own view, the court has to consider the appropriate margin of error in order to determine the bracket within which a non-negligent valuation would have fallen. And that depends on the facts of the case. And guidance is provided as to that from KS Lincoln. And again, probably no argument about that either. 3, if the impugned valuation is within the relevant margin of error of the court's valuation, then it is within the bracket of potential non-negligent valuations, and thus negligence would not have been established. Liability is to be established by reference to the results of the valuation, not purely and simply by reference to the details of how that result was arrived at. Now, 3, in our submission...
So what he's saying there is, if it's within the bounds, the fact that he was negligent along the way doesn't matter.
Or usually won't
Usually won't matter.
Usually won't.
I mean, the warning case might be different.
Exactly.
Something like that. Yeah.
Exactly.
And then it's 4.
If the valuation is beyond the margin of error in relation to the court's valuation, and therefore outside the bracket, then the valuer's competence and the care used in his or her valuation is called into question, and that clearly tracks the wording in Merivale. The court will examine at this stage the question of whether in reaching a valuation outside the bracket, the valuer has acted in accordance with practices which are regarded as acceptable by a respectable body of opinion in his profession, i.e. the Bowman-type considerations.
You say that's a good formulation because it avoids the burden of proof, putting too much emphasis on the burden of proof. He says at that stage, if the defendant has raised a lot of reasons why he's done it right, he will answer the question. The court will answer the question.
My Lord, yes. It more accurately, with respect, reflects the task of the trial judge, consistent, I think, with the points being made in the course of argument by my Lord Justice Snowden, and the explanation of what's really meant by evidential burden.
So you say 165 is correct?
165 is correct.
Can I just say that I do have some doubt about 1653. It doesn't seem entirely consistent with the approach we saw this morning from Mr. Justice Cawson of distinguishing between what might be regarded as negligence, i.e. failure to take care, and liability. And it's, at some point I'd like you just to address us all, help me with the point that you might see that somebody has been careless, if that's what you mean by negligent, often is, within reaching a valuation, but because the valuation is within the range that careful valuers could have got to, there's no liability. And the argument, I think Mr. Justice Coulson, we saw in a couple of cases, he was suggesting that's because there's no loss.
Yes.
And I'm not debating, as it were, the overall direction of travel of these 4 subheadings. It's just, I think within 3 there is hidden the conceptual underpinning between of what is this bracket actually all about, where does it come from?
And my Lord, it's hidden with respect because of perhaps the loose use of language, or rather using language without explaining really what one means by it. Because you could mean by saying negligence, the tort of negligence. And the tort of negligence is not complete unless you have breach, causation and loss. So captured within the wording there.
So you see, the way, I mean, in a sense, if you're thinking this as a practical guide to a judge, you can say to the judge, look, you may be able to short circuit this whole trial if you find the correct value and the margin and the valuation was within it. You don't need to go on to actually look at what the valuer actually did to see where they fell down. And it's only if you find somebody who's outside the bracket, then at that stage you do need to go on to look at the Boland type considerations. But just going back, that is saying in effect the bracket is not to do with defining the scope of duty. In other words, I think Mr. Rosenthal said, no, the bracket is relevant because the duty of care is to land within the bracket. and I'm not sure whether you'd agree with that or not.
My Lord, I'm anxious not to be difficult. I'm not sure I have to agree or disagree for the purposes of succeeding on this appeal. But in order to assist the court, we would, in my submission, I would disagree with that proposition for reasons I'll come to. Because
I thought you might actually,
because what's if I can put it this way, pregnant within or requires unpacking from point 3 here is the breach loss distinction which Mr. Justice Cawson makes in K.S. Lincoln, which my Lord Master of the Rolls makes in Denard, and in our submission actually unlocks the position and provides the answer.
You pass to 162. The phrase the judge uses is 162.2.
Yes.
162.1 is very long. 162.2. In any event, a precondition of liability.
Yes, liability, not breach.
Yeah.
And
A precondition of liability, if it has to be either duty or causation, either breach, causation, or loss. I suppose it's causation of loss, is it?
It is.
can I, just following on from this, then put just an alternative thing to you just to think about, but it's the right time, I think, to do it. We've all been talking here about negligence, tort, but what the valuer is actually contractually engaged to do is to produce a valuation, and I think it would be said by implication, if not expressly, to take due care to do so. Now, if he doesn't take due care to produce his valuation, he commits a breach of contract.
He does.
If you were to then ask the question, what are the damages? I think you would ordinarily approach the assessment of damages for breach of contract on the basis you'd say, well, what is the way in which somebody could have performed the contract in a way which produces the least harm to the claimant? Now, you would then say, well, contractually, a valuer could have produced a valuation which, let's say at its lowest, that's where the level was.
Yes.
And therefore, if in fact the value that's actually being produced, even though as a result of a breach of duty, is within the range, there's no damages for breach of contract.
The same result is reached through the contract cause of action as the cause of action in tort by a slightly different route.
But the point being, in each case, what the bracket is doing is focusing on loss.
Is that right? Do you get damages in these cases, assuming you're outside the bracket? Do you get damages that reflects the difference between your valuation and the edge of the bracket, or do you get damages that are the difference between your valuation and the middle of the bracket?
Traditionally, you get damages by reference to the difference between your valuation and what the court decides is the true value.
So the middle of the bracket.
So the middle of the bracket.
Which falsifies the point my lord is asking.
Well,
my learned friend. That used to be my learned
friend. But that was something that was itself a further proposition which Mr. Justice Lewison, as he then was, had some difficulty with in Goldstein.
He thought it would be it should, in theory, be the difference between
exactly.
the edge of the bracket and the.
He was with my lord. Yes.
I can see, why he might be.
Yes, and
he's very learned.
He is.
but can I?
You both are.
Could I? I think just take my lords to K.S. Lincoln again briefly to see how Mr. Justice Cawson, as he then was, draws the distinction between breach and liability, because I think having done that, and given what I've said so far, I will then muster such courage as I have to try and draw the threads together into what I think will be 5 principles that might guide.
Hang on, where are you now?
So I was going to invite my lords back to K.S. Lincoln in the authorities bundle at tab 3, and to begin at page 78, please, and paragraph, this is under the heading law.
Yep.
And at paragraph 141, having referred to Goldstein.
It's the words in italics that
Exactly, and quite,
draw it out.
it does. It's in our submission, quite telling that the learned judge decides to place emphasis on the words here by using the italics, all pointing exactly the same way, that is the authorities, that whilst a valuer might be in breach of duty because he fell below the standard of reasonable value in his methodology, the valuer will not be liable in negligence if it can be shown that, notwithstanding the error, the valuation figure that he produced was within a reasonable bracket. Then he refers to, first of all, Merivale, and at 144 makes the point on Merivale that it seems plain to him that Lord Justice Buxton was making it plain that a discrete breach of duty in arriving at the valuation figure would not give rise to a liability unless the valuation figure produced by the breach was outside the permissible bracket. Subject to the next issue, I consider that conclusion binding on me. And then at the end of 145, one sees again reference to liability not being established rather than breach. Next, the learned judge turns to Goldstein before then setting out his own views in the passage to which my learned friend helpfully took my lords this morning, beginning at paragraph 149.
It's 151.
It's 151 and 152.
Last sentence.
Exactly same.
That's where he explains what he means by liability.
And then he gives the rather striking example at 152 of two counteracting or cancelling errors.
Any discrete breaches would not have caused any loss, and therefore there could be no finding of liability in any event.
My lord, yes.
And
And that finds its echo in paragraph 134 of my lord, the Master of Vaux' judgment in Denard.
yeah, and it's perhaps a clue to what the judge was saying in this case in 1622.
My lord, yes.
In any event, there is a precondition of liability.
And my lord, having gone back to those passages in the authority and taking it as read, so to speak, passages in Merivale with which we're all familiar, can I seek to identify how one might draw 5 propositions?
5 propositions.
5 from those. The first is that, save in what today might be a rare case where a valuer is instructed only to produce a figure, ordinarily a valuer will owe a duty both in contract and in tort to produce a competent valuation and to exercise reasonable skill and care in doing so. Now, just pausing there, the qualification at the outset of that proposition is to cover what I've described as the rare case, where the valuer is only instructed to produce a figure.
And you say he has to produce a competent. Just sorry, I wasn't quick enough to keep.
I'm sorry, I'm so sorry, Ron. Save for that rare case where the valuer is instructed only to produce a figure, ordinarily a valuer will owe a duty both in contract and in tort to produce a competent valuation and to exercise reasonable skill and care in doing so.
Why is it different in the figure case?
Well, the figure case, what I'm trying to do there with the qualification is to cover the rare case where, as a matter of contract and tort, the valuer's duty is limited to producing the figure and owes no duty.
It's just to give reasons, isn't it? I mean, surely the whole point is, in many ways, you're under a higher duty to take care if you aren't obliged to show you're working. I mean, it's just the difference is only as to whether you're required to give reasons. But I can't see why. I think what Master Oz was just putting to you, why you under. You must be under the same duty whether you're required to give reasons or whether you're not.
I mean, the principal reason why I put that qualification there, and it probably doesn't matter, is to hold full still the opportunity to explain the approach through the prism of duty as well as loss. Because if one takes what I've described as the ordinary case, where there's a duty to produce a competent valuation and to exercise reasonable skill and care in doing so, then that takes me to proposition 2, which is if the valuer is careless, then he will be in breach of duty, but there will be no liability in negligence if he nevertheless produces a valuation within a competent range.
Or indeed contract, unless you're going to give contract as a separate heading.
Yes, I mean, I think you can deal with contract subject to the footnote, so to speak, that my lord and I were discussing earlier about measures of damage.
So if he's careless and in breach of duty, but no liability, is this right?
Because the client ultimately receives what it was entitled to, namely a competent valuation, and therefore any breaches in the methodology.
Sorry, I'm not sure. I've got lost. Can you repeat it? If the valuer is careless,
So careless in method and approach,
right?
there will be a breach of duty, but no liability if he nevertheless produces a valuation within a competent range.
Well, a reasonable range is what you said before, and I think that's a better formulation.
I'm happy to stick with what I said first time.
Because competent range is the valuer is going to have to use a reasonable range.
Yes, it muddies issues of breach again with liability.
Yeah.
So it's better to keep it clear. I accept that. So
And you say because the client gets what he's entitled to.
a valuation within a reasonable range, and there's no causation
But
and no loss.
sorry, I'm not sure I agree with that formulation. The client hasn't got what he's entitled to. He's entitled to a careful valuation. It's just he's suffered no loss because a careful valuer would have put him in no better position. But your postulate is somebody who has been careless, and by definition, that's not what he's entitled to.
No, he's yes. So as a matter of causation,
Yeah.
yes,
There's been a breach, but it hasn't caused loss.
loss
Yes.
because he's in no different position than
Yes.
if the valuer had exercised skill and care.
Yeah.
Now, the third proposition is that if the valuer's value is outside the bracket, and I'm using the bracket for the range of reasonable valuations, then there is a prima facie case of both breach and indeed causation and loss. But at that stage, the court still needs to consider the Boland test as to whether there has been a breach, as well as the issues of causation and loss, of course. And it follows, and we accept, that if the valuer has produced a valuation that is outside the range, then the valuer is likely to face some difficulties. But the fact that the valuation is outside the range is not conclusive. And that's consistent with, in our submission, Merivale, outside the range being a necessary precondition of liability, but not providing the answer in and of itself. The fourth proposition seeks to address the position where the valuer is careful, so careful in approach and methodology, but nevertheless produces a valuation outside the reasonable range. And here, in our submission, if when setting the range, the court has considered at each stage of the valuation method how a competent valuer would have discharged its duty, and considered what the defendant valuer itself did, then the defendant valuer can only have been careful if there is some exceptional feature. And this is the edge type case that the judge discussed with my learned friend Mr. Allen at trial. And can I seek to try and explain how that might be by reference to the edge type example, which the judge gives at paragraph 82 of his judgment, Core Bundle, tab 7, page 95. Let me try and develop the example a little more, because I would hope that makes it clearer. Take a case like Capita, where my lords might recall on the facts that the valuer's valuation of the, in that case, shopping centre, relied, at least in part, on an input provided by another expert, a consumer retail expert. And if one just changes the facts of Capita slightly to make the example a little clearer, there may be a case where the defendant is instructed to value a particular property relying upon inputs provided by a third party. So a factory outlet shopping centre relying on a consumer spend analyst.
Or relying on a quantity surveyor like Mr. Pillinger.
Exactly. Now, there may be an issue in the case as to whether the valuer was entitled to rely on the information he in fact received, or whether he should have identified errors within it. The court has a choice in reaching its findings as to true value and range. It could reach its findings as to true value and range based on the correct information which should have been provided to the defendant but was not. Or it could reach its findings as to value and range based on what the defendant was in fact provided with. Now, if the court adopts the former approach and says, well, my task now, as the trial judge, is determine the true value of this property at the valuation date based on accurate information. So I'm going to do that exercise based on the expert evidence that I have, which will include accurate information, which was different from the information that was erroneous that was provided to the defendant. And if I set my true value, and if I decide based on all the evidence what my range is, and the defendant's valuation is nevertheless within the range, then subject to everything else that I've said about the role of the range, that's likely to lead to the defendant being found not liable. And issues as to whether the defendant was entitled to rely on what he did or wasn't, or should have identified errors in it, will then fall away. If, however, having done that exercise, the defendant's valuation is outside the range, then the court goes on to consider, well, was the defendant actually entitled to rely on the erroneous information that he did? Did he exercise reasonable skill and care in all other respects of his valuation? And the answer might well be yes, he did. And that is the type of case where the valuation is outside the range of what the court has decided is the true reasonable range of values, but the defendant has nevertheless discharged his duty.
Mm. Well, and that's very important to realise, because if the surveyor is asked to undertake a valuation on a false basis, it may not be the beginning and end of, it would not logically be the beginning and end of the case to determine what the true value of the property was. In order to do it in the same way as you would usually do it, you should be determining what the true value of the property was based on the false information he was entitled to rely upon.
Yes.
And then if he was outside the range of the true value of the property based on the information that he was entitled to rely upon, he would be liable, and if not, not.
Yes, and looking at the other way, if he was within the range of reasonable valuations based on the accurate information which he wasn't provided with, then the claim is going to fail on causation grounds and loss grounds again, for the reasons that we've been discussing on the earlier principles. So it's quite important to identify that there is that conceptual possibility. And then the fifth...
That's what they're always... This is what they're always trying to drive at, but never formulated in a very clear way.
Well, my lord, that may be the case. And another example, further away from... I'm sorry, my lord.
Well, no, I was only going to say, I mean, I'm struggling in many ways. I see a sort of certain coalescing in the approach, because I suspect Mr. Rosendahl would simply say, well, what you're accepting there is if in these paragraph 82 scenario, the court just says, well, I've just found the correct value using the correct inputs and apply a margin, and this value is outside it. And as Mr. Rensall said, well, that's it, you sit back. Then the valuer would invariably say, yes, but the evidence is that I was given the wrong input and I didn't have to check.
Yeah, so that...
and that's the way, in a sense, the evidence of trial, or the inquiry, in inverted commas, given that judges don't inquire, but they just hear evidence and then determine on the basis of all of it. That's the way it would play out.
It's the way it would play out on that case. To give another example, which would fall within my fourth principle, if one takes a case like, I think, Dunfermline, where even at the time of trial, there were no good comparables, and there certainly weren't any good comparables when the valuer was doing the valuation, and so they were confined to a residual value approach. If, in fact, by the time of trial, there are some good comparables, and the experts have been able to use those, then one can see that the court would be attracted to the idea of actually fixing upon what the true value of the property was at the valuation date, based on the best available evidence before it. It could be the case, for example, that the comparable is a transaction that took place on the day of the valuation or the day before. There's no criticism that the valuer wasn't aware of it, but the court now has the very best available evidence to fix the value. And it could fix the value, it could fix the range, and if the defendant's valuation is within the range, then subject to everything else I've said, in principles 1 to 3, the valuer will escape any form of liability. But, going back to why there is this second stage required, if the valuation is outside the range in that case, that doesn't answer whether the defendant valuer has acted negligently or not, or rather in breach of duty, because then there has to be a further inquiry as to, well, how did you go about doing your valuation based on the information that was available to you at the time? So there are these possibilities, and they're not...
That seems to be what the judge is sort of alluding to in 1662.
Yes, I think it probably is.
So the judge in 1662 is saying, well, there are some cases, and actually Denard was one of them, where the allegation was that there were 2 or 3 things wrapped up in doing the valuation, and I think I said I had to look at those 2 or 3 things to decide in turn whether there was negligence in doing those 2 or 3 things before I could evaluate the overall bracket and value. And the reason for that was that, and it does make sense, your fourth point, which is that I may have been given at some point wrong information, the valuer may have been given wrong information, or the valuer may have proceeded upon a justifiable false assumption, so that the actual valuation is not the beginning and end of it in some cases. I mean, it's quite complicated, actually. And you can see why the people who wanted to set out principles and say this is the beginning and end of valuation cases and don't look beyond me, got into trouble. I mean, it's the reason why I repeatedly say to judges, don't set out principles, just decide the case, because cases are decided on facts. And principles may be jolly helpful to judges and barristers and clients even, but you've got to be very careful that you've actually had argument about all the possible permutations and combinations, which in this situation you almost certainly won't have.
And that then leads perhaps to an understandable, to put it inelegantly, fudging of the position when the principles are addressed and set out in the authorities, a position which leads to a certain absence of clarity, which is then worsened by some of the loose language.
But it does answer the logical fallacy. I mean, there are 2 answers to the logical fallacy. One is loss. One is the proper analysis of liability, which is duty, breach, causation, and loss. And the second answer to the logical fallacy is that there are situations where valuers are asked to do slightly more complicated things than just go off your own volition and give us a valuation with or without reasons, because the valuer is provided with certain information which makes them go wrong, in which case you can't, the court, in assessing that valuation, can't just start from finding the valuation as it should have been on real information without evaluating what was given to him that was wrong.
My lord, yes. And I think what that then leaves is what was going to be my fifth.
Yeah.
I don't want to call it a principle now, given the.
It doesn't. But also comments about propositions don't apply in this court.
Just before you leave,
With my lord.
just before you leave, what may or may not have been for. I was intrigued by the other alternative idea you gave us to paragraph 82. You said, take a situation where a valuer is instructed to value a piece of property and there are no comparables available to him at the time that he's required to produce the value. And therefore, for example, he uses a residual. He goes, in a sense, back to basics and does the sort of thing that somebody in the market would do to make an offer for a piece of property or for a property. And we know that residual valuations, and Mr. Rosenthal said this, I mean, residual valuations are very much more dependent upon the inputs and have a wider margin for error.
Yes.
Which is why he said comparables are necessarily the better choice if you've got them. So that the valuer goes off and uses a residual or residuals and produces a result. But at the time or very shortly thereafter, it is apparent that there are comparables in the market which he wouldn't have known about, couldn't have known about, was not careless in not knowing about, for example, because they hadn't been published. You know, nobody knew that the sales had taken place, for example, but they were directly comparable. The court, in fixing the correct value, would turn to the comparables because they're better. And if it turns out that the valuer was outside the margin, fixed using the comparables, it doesn't mean that they were negligent.
That's right.
Because they used residuals, which are all that was available to a careful valuer at the time, and they did the best they could, and nobody suggested otherwise.
I think that's the same point as I've been putting there.
It is,
It's just
but I'm
with
just
a different
making
example.
Yeah,
It
just
was a
making
different
sure we've just nailed it down. I mean, one was error in input
Yes.
And the other is
from a third party.
error in availability of info.
Yes. The
And-
second
and-
is perhaps a
and
slightly
it-
more straightforward
Yeah,
example.
and inherent, greater uncertainty in evaluation technique
Yes.
than using comparables.
Yes. And I would agree with that. And
okay.
the
Very
fifth
interesting. I mean, this is an
Yeah.
interesting case.
This fourth
actually.
proposition is actually quite important, isn't it?
is
Extremely
Because
critical.
this is the proposition which is going to arise in most complex contested cases, which are likely to end up in court. So if it's not clearly understood and propounded, it's a greater risk that more cases will end up in court for the lack of clarity as to what the test is.
Well, I think, my lord, with respect, yes, that's the risk that my lord Master of Rolls, I think, was referring to in
But we haven't, luckily, we haven't had, if we look over the entire period since 1977, which happens to be the year in which I started my
Was.
pupillage.
You were called to the bar.
You too.
No,
No.
year later.
But anyway, it happened to be that year. If we look at that entire period, we appear to only have about 10 or 20 cases. So,
and only 3 or 4 that reached this court.
it's still quite interesting. Could you give us your fifth proposition?
My lord, yes, because I think it's important to complete the picture with the fifth.
Yes.
The fifth proposition is that a within bracket valuation can still give rise to liability if there has been a breach in the valuer's methodology or reasoning, and the breach is something upon which the claimant is entitled to rely and can demonstrate that the breach has caused him to have suffered loss.
This is outside, as it were, the first four.
This is outside the first floor. This is Merivale.
Yes, and
Well,
also my lord said it in Denmark.
Paragraph
Well,
100.
this is very important because you take the example of a valuation that in a case for a dwelling house that 5%, say, you know,
Yes.
in my Neasden example of, there's hundreds of transactions, and you get a within bracket valuation, which looks perfectly good, and you get reasons that show that it has relied upon the fact that there is an outhouse which is valued at £1,000, but there isn't. He'd confused it with another house. Everything's right, but he has negligently, genuinely failed to add or subtract £1,000. Is that therefore negligence which sounds in damages? And on some of these principles, it would sound as if it doesn't, but why shouldn't it?
Well, on that example, the answer is that it wouldn't sound in damages, probably because of causation and loss, because the overall valuation is within range.
Yes.
So what you're looking for is something as per Merivale, where there should have been
A warning.
of this is within range, but my goodness, this yield is bullish and subject to a higher degree of risk, and you should know that. There may be other examples of...
I mean, why, just conceptually, why is the outhouse... I mean, if he'd done his job, he would have not got the outhouse, made the outhouse mistake. And you would have got a valuation which was not only within range, but was also £1,000 more.
Lower.
Or lower, it doesn't matter. Actually, if you could show that you were relying on the valuation for a purpose which was named to be dependent on the precise figure, why didn't you suffer loss?
Now, I think with respect with that additional characteristic, you would then be in the Merivale type case, or certainly closer to it, because ordinarily, and this is why Merivale is quite a difficult case, because ordinarily you would not expect there to be a duty to be qualifying or explaining your valuation in the way that there was found to be a duty in Merivale. But if one goes back to the contract and the duty, if the valuer is being asked to provide a valuation for a particular purpose, and
Yeah, I mean, if it's a mortgage valuation,
it's not...
unlikely to suffer loss. But if it's, and that's mostly, but if you're, I mean, something that I'm quite familiar with is valuations where willing seller, willing buyer wants a valuation to put into a transaction. You say, I'll buy this, and they say, I'll sell it to you, but we don't know what it's worth. So you go to a valuer, say, Red Book valuation, please, and the valuer makes £1,000 mistake. Nothing to do with ranges. If I'm the buyer or I'm the seller, the seller's losing £1,000 because they would have agreed, and everybody knew they were going to agree the valuation. Surely in that situation, you can claim the loss.
Well, then I think you are back to the explanation given on my proposition 2, because ordinarily, as my lord says, if it was a mortgage valuation case for a standard property, the error in the methodology and the error in that sub-conclusion, if I can put it that way, that informs the overall conclusion as to the value, would not cause the claimant to suffer any loss. But on the type of hypothesis that my lord puts to me,
It would.
It would. And that's why it's quite important in my submission that proposition 2 is there to explain why in the ordinary case there is no liability.
I mean, yeah, I do find some difficulty with this because if you accept that valuation is a science, an art, not a science, i.e. that, I mean, all these cases we've been looking at are premised upon effectively what Mr. Justice Tasker Watkins said, way back when.
June the 3rd, 1977.
Indeed. Which, he said it's just not something which can be performed, it rarely, if ever, admits a precise conclusion. I mean, the whole ethos of all these cases is that valuation is something that doesn't allow
Yes.
for a specific, and therefore all you what you want is a careful valuation, and you want a number, but you accept that that valuers can reach different views.
And anyway, it's my example is unlikely to ever work, because either he puts it in his valuation that there is or is not an outhouse, in which case you
know about it.
You know about it, and therefore you have to feed it into your own figure, or he gives no reasons, your example, in which case, unless you ask for reasons, the best you can possibly expect is a figure within the range.
And it does go back to what the valuer is instructed to do. Because another example, perhaps closer to Denard, in some ways, and this is one of the difficulties, we talk about valuation, of course, that covers a very, very wide range of different valuations of different types of properties, businesses, and so forth. But you can see how a valuer may be instructed to value a business for transactional purposes and get one element completely wrong.
Well, I mean, discounted cash flow valuations are very, very complicated, and there's all sorts of factors which are capable of being got wrong, and there's, you go through the process, PE values and all sorts of things, which are all market related and can be changed from day to day. I mean, you might look at the state of a market one day and be entitled to take one value, and another day another.
Yes.
So the percentages there for reasonable valuations would be likely to be much higher.
It's always difficult, isn't it, to take various different examples rather than the facts of the particular case before the court. But grounding myself again in a property valuation case, you can see an example perhaps of a mixed-use property which has residential, retail, and commercial, where the valuer, using Mr. Justice Cawson, then was counteracting mistakes, it values one element too highly and another too low, so that the overall valuation is within range. But if, for example, it really mattered what the commercial space was worth, because the potential purchaser was immediately going to sublet that on as part of the transaction, and the instructions, so the scope of duty were that you had to get each element correct, then one could see that actually that liability should attach for the reasons that the Lord Master of Rolls has identified.
And that's what my Lord was saying in the very last sentence, paragraph 164 in Denard, isn't it?
134.
134, sorry, 134.
The last sentence.
Last sentence, 134. Right, okay.
Do these propositions apply outside property valuations? Is this an all-encompassing series of propositions for all valuers, or just property valuation?
Well, now my Lord might forgive me if I say that none of this is necessary to defeat the appeal, and now we're even further away from what might be necessary to defeat the appeal. But in principle, one can see how it could apply to all values, because the starting point for the rationale for these approaches is that valuation is
A term of art.
a term of art.
As
of science.
opposed to art.
So one could see that, but
Art of science.
it does inform the caution that against which setting out any propositions of this sort has to be viewed, because you could set out the 5 propositions and they might work quite well for valuation cases. They might work particularly well for a valuation case such as the present, but one might then have them tested by the fact.
It's not going to be particularly helpful to point out how everybody else has got it wrong without actually going on to suggest.
Well, I think it's incredibly important in this field to point out some of the things that I did point out in Denard, which is that, and maybe people will listen now, they perhaps didn't then, that actually facts make cases, and you can't slavishly apply a rule if there are different facts and different circumstances, and you have to be incredibly careful about thinking that for example, claimants, I think, probably customarily go and get another valuation. They say it's outside a sensible range. I'm suing. And they don't put any more particulars forward, but the range. And that's a perfectly sensible thing to do, probably, in some simple cases. But if the valuer then comes along and says, but you told me this and you told me that and I quite reasonably did this, then the case can enter a completely different phase and you might have to amend your particulars of claim to stand a chance of success or put in a very serious reply. So, it's, as I say, it's horses for courses. And I think some of these cases have been... Do you remember, well, you're probably too young, all of you, to remember, the cases like Garlou on causation of loss, where Lord Justice wasn't Stuart Smith, but it was Coombe. Anyway, one of the Lord Justices of that very ancient generation said that causation was all a matter of fact.
Yes.
And that held sway until Lord Hoffman, in the Supreme House of Lords as it was then, said, no, it's not. It's a question of law. And it all came down to scope of duty, if you remember, and causation was all about scope of duty. And we now know the position. But I think this area of law, which is why I'm afraid I'm getting interested in it, is precisely that situation, that people have said things, very general things, intended to apply to every valuer's negligence case without thinking of the very different types of cases that arise.
Well, and my lord, I think it was for that reason that my own friend, Mr. Allen, who appears with the end of course appeared below, identified the logical fallacy in the course of his submissions.
Mm. And the judge has carefully thought about it. I mean, he may have. We'll have to look at it very, very carefully. But Mr. Rosenthal may well be right that he did fall into error somewhere.
Well, I think you have our submissions why we say that that's not right. The last thing perhaps I should add on this.
But you say it may not matter if he had.
Well, one, he didn't, and two, it's accepted. It goes absolutely nowhere unless any of the other grounds of appeal succeed.
I mean, this very interesting discussion in which we've been far too interventionist has left not much time.
No, but
Can I just raise one point briefly? What's your final riposte to the points made about evidential burden?
Well, my lord, I can do no better than point to the explanation given by Lord Justice Snowden that it is only an evidential burden, and ultimately, as the authorities make clear, what has to be established, and one sees it in capita in this court, is both outside the range and a breach. Now, in many cases, this where we go back to the point made by my Lord Master of the Rolls, on the facts, if you're outside the range, there may not be much more to think about.
Yeah,
and in other cases...
So you used a phrase in your 5 proposition, I think it was in proposition 3, it follows in no circumstances, I think the valuer would face some difficulty.
Yes, in the ordinary case. But
that is an observation, it's not a...
It
doesn't intend to imply a proposition.
Can we ask you to do something for us?
Yeah.
Which is to put those 5 propositions on a piece of paper carefully, and only because I think we may all have written them down slightly differently because you were stopped and interrupted and generally harassed.
Probably said them 3 different ways as well.
Possibly, and it would be useful, I think, if you were to just put them down for everybody's benefit, and we'll obviously give Mr. Rosenthal the opportunity to say, well, you didn't say that before, and I've got this comment. But I think not necessarily because we're going to set out 5 propositions, part share what I just said, but I would like to see the way you put it, because you've obviously thought about it quite carefully.
We will do that, and do that with expedition so that you have it.
Thank you. I'm sure we can give you.
I mean, speaking for myself, if you don't put it down in precisely the words you actually first spoke in light of the debate, I wouldn't personally object to that. I mean,
No, I'm not encouraging you to not to tweak it so that it reflects precisely what you think the correct legal position to be.
But we will do that.
But we do want to give you the opportunity
yes.
to talk about ground 2 and 3.
Well, yes. And can I just make one very short final
Seven.
point? Is that with all that said, it is important, I think, as the point was made below, to bear in mind that the bracket is only a tool. It's a tool that's used by the trial judge to make findings, and that's perhaps the overarching cautionary note that applies to all of these propositions. Is that
Well, your submission is that the law of negligence and breach of contract is not different to for valuers than anybody else.
well, yes.
Oh, no, sorry. It may not just be a tool. If in fact if it goes to the question of causation and loss, it actually cuts it off. In that sense, it's a real scalpel. I mean, it's not just a useful thing to do. It's actually essential because it enables you to say, even if this was done carelessly,
Yes.
it goes nowhere. And I think that's rather what Mr. Justice Cawson said in his case. I mean, as we saw at paragraph 151, I think, question mark, where does it take us?
Where does it take us?
Well, I mean, you mustn't forget also the great Mr. Justice Tasker Watkins, who quite rightly said, what you're doing as a valuer is not necessarily the same as, say, an actuary.
Yeah.
I don't think he said that, but you know what I mean.
Yeah, that was the gravamen of the point, yes. My lords, ground two, the bracket. Here, with respect, we say that the appeal is based on a misunderstanding of the law and how the judge applied it, and then a misrepresentation of Mr. Buckingham's evidence. As my learned friend Skeleton at paragraph 47 acknowledges, the judge did direct himself by reference to the relevant authorities, and in particular KS Lincoln. As to the law, my learned friend relies, particularly in his Skeleton, on Titan and paragraph 6.5, but as was pointed out in the course of argument, in Titan the law was not in dispute, certainly not at first instance. And in the Court of Appeal, Lord Justice Longmore was simply quoting from the summary provided by the trial judge. In any event, the prior paragraph to that upon which my learned friend relies, he relies on paragraph 6.5. Paragraph 6.4 makes it clear that the determination of the bracket, while a matter for the judge, will depend on the facts of the particular case. And of course, that's entirely consistent with the Court of Appeal in Merivale, where Lord Justice Buxton tells us that we are not to determine the bracket in a mechanistic way, but with regard to the particular facts of the case. And it is also unsurprisingly consistent with the decisions of Mr. Justice Cawson in both KS Lincoln itself and Webb. In KS Lincoln, which is in the authorities bundle 3, I'm conscious we've looked at this quite a lot already. Page 86. The learned judge begins with the margin error at the bottom of the page and starts with the paragraph from Singer and Freeloaner, which we've been looking at and about which I say no more. But it is clear, if one looks at paragraph 183, that what the learned judge there is not doing is setting out the 5, 10 and the...
I think we've got these points, to be honest. I mean, and you got my lord's point earlier, which presumably you associate yourself with.
My lord, yes, that it depends on the facts. Just while we are here, though, there's perhaps one point over the page, on page 88, that I should address, because my lords will recall that my learned friend said when criticising the judge's approach that because there was only one comparable, that was a reason why the range should be narrower. And of course these cases are determined on their own facts. But at paragraph 189, in setting out the factors which the learned judge took into account in Lincoln, my lords will note from paragraph 189A that in that case too there were limited comparables, but that was a reason why the range should be bigger, not smaller, because you've got fewer comparables upon which to base your analysis. And one sees that...
what do you say about the 10 to 15% point? 15%, if it's 10 to 15%, you should take 12.5.
Well, Lord, the judge here really based himself on Chaos Lincoln, and the finding in Chaos Lincoln was that the range was greater than 10, could be up to 15, but ultimately it didn't matter in that case.
But the truth is, he took 15.
He did, and it didn't matter in Chaos Lincoln because they were within the valuations were within the 10%.
No, but Mr. Rosenthal's point, which I thought was quite nifty, if I may say so, was he'd said 10 to 15%, and then he took 15. I mean, it's obviously open to him to take 15.
Of course.
But he'd said it could be 10 and it could be 15 in this case, and I'm taking, and then he said it was 10 to 15, but of course he applied 15.
But if logically a valuer could carefully say 15, then if you were assessing damages, for example, for breach of contract on the basis that a careful valuer could perform that way, the contract in that way, and say 15 apart, you would use that as the basis for a determination of loss, and there wouldn't be any.
My lord, he would, and ultimately, having decided it was greater than 10 and up to 15, as Mr. Justice Cawson did in Chaos Lincoln, the judge was entitled, for the reasons he gave, to say at 14.15%, 14.15%, the valuation, it seems to him, was within range. And he gives the reasons as to why he's taken that approach in the judgment. And those reasons, when you stand them side by side, mirror in large part the reasons that Mr. Justice Cawson gave in Lincoln, and indeed in Webb.
You were going to say something that supported 189A when I interrupted you.
Yes, earlier in the judgment in this case, although my reference now escapes me, the learned judge in that case effectively found that there was one particularly helpful comparable. Yes, paragraph 161 at page 83. He identifies that the Travelodge, no less in Sutton, Scotland, was the single best comparable in this case. And so it bears some similarities, and therefore, in our submission, is unsurprising that the judge drew comfort from both the approach and the outcome in both K.S. Lincoln and Webb, and indeed...
Sorry, which paragraph are you referring to?
Paragraph 161, my lord.
161.
Page 83.
Scotland.
Yes.
Great.
Long way from the Central Hotel in Glasgow.
Yes. Now, it seemed to be the Graven of Malone Friend submission at one point that the authorities, and in particular Lincoln, suggest it's 10% and always 10%, not 1% more, not 1% less. That's, in our submission, clearly wrong. It's a evaluative exercise for the judge on the facts of each case. Indeed, we say, of course, there's nothing in it here, but this may be a way of taking things shortly, because it will give an indication of what we say about Ground of Appeal 7. But if one looks at how Malone Friend deals with Ground of Appeal 7 in his skeleton argument at paragraph 77, tab 3, page 77.
Para 77.
Yes, I think
You said
that's the wrong reference.
No, maybe not.
It's paragraph 77.
Yes.
Applying the judge's methodology at J233, but substituting a value for each market plot.
Yeah, so here's where my learned friend gives my lords the a la carte menu.
Yeah.
Pick one of these as an alternative to what the judge did, and my lords will understand what we say about that as a ground of appeal. Interestingly, it must be implicit in what my learned friend says that it would have been open to the judge to pick any one of those valuations, ranging from 5.8 million all the way up to 7.4 million.
And take 100,000 a plot off.
Or whatever you might like to do. The short point on this is that, my lords, that is a difference of £1.57 million. It's a range of 26%. So even if one took the midpoint of these valuations, it's nearly 12% either way, on the basis of the case that the appellant itself wishes to put forward. So any suggestion that it's 10% is always 10% is rather contradicted by the, we would say, hopeless grounds of appeal, but nevertheless the ground of appeal that's advanced by way of ground of appeal 7, where the appellant itself implicitly is relying upon a larger range than the 10%, which it contends is the only answer here. Then there's the bizarre point where a distinction.
Does your skeleton have that number you just gave us for the percentage margin?
I'm not sure it does, my lord.
Can
But
you skip us again?
It's so the top of the range is 26% higher than the bottom. If you take the midpoint between the lowest figure and the highest figure in that paragraph in my learned friend skeleton.
Yeah, when you say 26% higher, does that started with the bottom as your reference point, and the top is 26 higher than the bottom?
It is, and then being fairer, if you take the midpoint,
and then you want the degree of deviation either side.
it's 11.8%. So implicit in the submission,
Taking the midpoint as the reference point.
yes,
Yeah.
yes,
11.8, you say?
11.8.
Still not 10.
That's the point. I mean, it doesn't. I accept. It's a forensic flourish that
It's
not-
a bit of a
that
forensic
does not
flourish.
add greatly to the weight that comes from the analysis of the authority. But even given the time, it's a point worth making. The next point to deal with very briefly at a canter is the distinction my learned friend seeks to draw between somehow the court being entitled to look at expert evidence as to the difficulty of evaluation without looking at the percentage. With respect, that distinction is artificial, illogical, and wrong. An expert can give evidence as to what the practice is based on their experience of how valuations of the particular type of property differ, and differ legitimately and competently, and that's what Mr. Buckingham did in this case. But I'll just give my lords the reference. I mentioned it earlier. The expert evidence in the authorities upon which my learned friend relies did descend to giving expert evidence on the percentages, just as it did in Singer and Friedlander. So in Lincoln, one can see at paragraph 184, at page 87 of the authorities bundle, that there was evidence as to expert evidence as to the percentage. In Webb, it's at paragraph 29 at page 261, and in Dunfermline.
So Web 29.
Web 29, my lord, yes. And in Dunfermline, it's paragraphs 50 to 51, page 370 of the authorities bundle. Interestingly, in that case, Dunfermline, both experts agreed that the range was 15%. And I think it's right to say that one of the experts, Mr. Fort, is the same Mr. Fort who was an expert for the claimant in this case.
The fact they agreed 50% on the facts of that case is neither here nor there, as a matter of fact, is it?
Another forensic flourish, was that?
Well, it's
Mr. Never 15% expert, is it?
well,
Or sometimes he is. I mean,
No,
it depends on the facts.
there are 3 points, my lord. It depends on the facts. Secondly, the facts can be determined by the trial judge by reference to expert evidence which descends to percentages. That's the point from these cases. Third point, forensic flourish, is that the claimant in this case adduced no evidence in answer to Mr. Buckingham's evidence
Okay, that's a different point.
as to range, which is a different point, notwithstanding that their expert is apparently capable of doing so in other cases. Now, that's so much from misunderstanding of the law. As to the evidence, the last point is, of course, one I would wish to make. The judge took into account Mr. Buckingham's evidence, which was that the range could be 20%, but he thought it was somewhat tighter, and probably 15% due to the good comparable, albeit only one, that existed. And his evidence, I think, is to be found in the passages to which my Lord Justice Baker took my learned friend during the course of argument at the supplemental bundle, tab 17, page 193, as well as 202 and 241. And he kept to that evidence in his cross-examination, supplemental bundle, tab 26, page 511, where he did not say that there was nothing exceptional about the site. What he said, there was nothing exceptional about the valuation of the site as a development site, and then went on to explain that it contained all of the various different elements he would expect to see, and then went on to explain why those various different elements and inputs made it a difficult exercise before restating his opinion as to what the appropriate range was. So, my lords, wrong on the law, wrong on the facts, and ultimately the judge was entitled to reach the findings that he did for the reasons set out and culminating in paragraph 237 of the judgment, Core Bundle tab 7, page 123, and for the reasons we've sought to explain in our skeleton argument, at in particular paragraph 35, that we address this whole topic from paragraph 22. My lords, can I, at a canter, given the overarching point I've made about the challenges to findings of fact, try to address some very short submissions on grounds 3 and 7, some of which I have foreshadowed already. As regards ground 3 and the enhancements, this is of course a clear challenge for finding of fact, and with respect, the appellant has not identified where the judge has gone wrong in the sense of that word by reference to the authorities. The judge made a finding on the evidence that was open to him. With respect, the judge himself deals with this rather well when refusing permission to appeal, which is Core Bundle tab 8, page 126, and it's paragraph 1, where in refusing permission to appeal he explains his approach to the evidence, and I simply commend that to my lords. Beyond that, it does, with respect, appear that this ground of appeal is based on a misunderstanding of the judgment, where paragraph 219 is key, which is at tab 7, page 119 of the bundle. And if I can try and take this shortly, particularly given the time, what the judge does in this paragraph, and indeed the preceding paragraphs dealing with this issue, is to say that there are two issues which he has to consider. The first is that there was the possibility that there were enhancements at the Bloxham Road site, the comparable property, about which Mr. Jones was not provided with information, upon which the evidence was effectively silent. But there was nonetheless the possibility that in addition to the abnormals, there were enhancements that were taken into account by the purchaser when setting their purchase price. And it's important here to understand that there are two types of enhancement being talked about. There are enhancements, the cost of which are effectively recovered through increased sale prices, and there are enhancements which will not be or are unlikely to be recovered in increased sale prices, and the latter fall to be taken into account for obvious reasons when fixing valuation and when adjusting the purchase price that was paid at Bloxham. So the first issue that the judge had to consider was that there may well have been enhancements at Bloxham which informed the purchase price that was paid at Bloxham. The second, having decided that Mr. Jones was wrong in his view to consider that all of the enhancements at the subject site would be irrecoverable, was that nevertheless there was an issue based on Mr. Buckingham's evidence, and indeed Mr. Jones' evidence and approach, that at least some of those enhancements, which were a known cost, were what I've described as irrecoverable enhancements and therefore fell to be taken into account in the purchase price. And having identified that, and having identified Mr. Buckingham's evidence, which he accepts, that some adjustment has to be made on the basis that there are some irrecoverable enhancements at the subject site, what the judge does in concluding at paragraph 219 is say that there's no exact science as to how to go about reflecting those two issues, so that there were enhancements at Bloxham.
But 50% is what I'm doing.
Doing the best I can, that's what I'm doing. Now, the challenge from a learned friend is to say why the judge was not entitled to do that, given that he's based himself on the evidence, including the expert evidence, and reasoned why he's done what he's done.
And indeed, I don't think my lords were taken to this, so I should, notwithstanding the time. He returns to the subject at paragraph 233, because having provided his judgment in draft, there was then an issue between the parties as to where that 50%, the £550,000, should come off the calculation. And it was suggested by my learned friend Mr. Allen it should come off at the top part of the calculation when grossing up Bloxham. And the judge said, no, I'm going to do it at the bottom part of the calculation. There is, we think, a typographical error actually here in this paragraph. He refers back to paragraph 215. We think he's actually referring back to 219, the paragraph we were just looking at. And he concludes that, nevertheless, Mr. Allen's suggestion does reflect there are a number of possible differing approaches as to how some provision might be made for abnormals and a margin of appreciation in respect thereof. We've given the references to the evidence in our skeleton at paragraphs 40 and 42, page 53. But the short submission is the judge was clearly entitled to form the view that he did and make the allowance that he did. Similar points can be made in respect of overheads and profits. Again, there's a challenge to the judge's findings of fact. My learned friend did say that the judge did not deal with this issue at all. With respect, that's not right. He does deal with it. And let me just, if I can, give some very quick references to that. First, at paragraph 28, Roman 6 of the judgment, at page 77, at the very end of the paragraph, the judge identifies the issue.
So 28
Roman 6, so immediately before paragraph 30. In the
29.
I'm sorry, 29.
Sorry, yeah, there was 29.
Sorry, 29 conventionally comes before paragraph 30, so I'm trying to take this too quickly. 29 Roman 6, forgive me. And it starts with the sentence about 8 lines up until shortly before trial. And you'll see there that the issue was identified by Mr. Buckingham. And the effect that had on the figures. So Mr. Buckingham, it's the schedule that my learned friend took the Lords to, identified that what Mr. Pillinger, the QS, had done was put all of the overhead and profits on the enhancements. And Mr. Buckingham said, well, you need to actually split that between the enhancements and the abnormals. And he then returns to this issue at paragraph, I hope, 55, Roman 1, at page 85.
I'm not sure I'm not sure he quite says at the end of sub 6 what you've just said.
No, I mean, you, my lord, it's right. You do need to read it with the other paragraphs that we're coming to understand.
Yeah, okay.
Right. What the issue is. And it starts to make more sense if you then have in mind paragraph 55, 1 at page 85, where he records the key differences of approach between Mr. Jones and the claimant's experts, and he returns to this topic at the end of this paragraph and says there is a question which I may not need to determine as to whether the figure for enhancements in fact includes a figure of £200,000 representing developer profit stroke contingency, which should not have been deducted in any event. So that's the ground of appeal. So he did identify that there was an issue, but identifies it's an issue that he may not have to determine in any event. Then at paragraph 116, on page 101, he records my own friend Mr. Allen's submission that the correct figure in any event for abnormals is the higher figure including the overheads and profits, and refers back to paragraph 29, Roman 6 above. And then at paragraph 213, at page 118, the judge returns to the issue, saying that as he's identified there's an issue as to whether total abnormals and enhancements figure for the site includes 1 million of enhancements or 1.1 of enhancements. At the end of the day, I do not consider that anything really turns on the difference, and so I do not need to resolve it. And the reason for that
is our old friend now, paragraph 219, where the judge says, I need to do something to take account of these enhancements, doing the best I can, it's 50%. And therefore he didn't have to decide, because he was taking an assessment in the round, whether that 50%, which equated to a figure of £550,000, included overhead and profits or not, because he was simply basing himself in the range of 25 to 75. So ultimately it was not an issue that he had to determine because of the approach he took, and because he was entitled to take that approach. Ground of Appeal 3.2 goes nowhere either. That leaves ground 7, where essentially, my lords, I've identified that which I was going to add to our skeleton argument orally. We deal with the position at a little length at paragraphs 52 to 59 of our skeleton, page 59 of the bundle, and we do say that this is, with respect, a classic attempt to overturn a carefully reasoned finding of fact. Ordinarily, you would expect such a challenge to identify the judge's finding, identify the particular finding that it said the judge should have made instead, and then explain with precision why the judge was wrong to make the finding he did and not the alternative finding, by reference to the evidence that was not taken account of or considerations wrongly considered and so forth. Here, the court is instead presented with an a la carte menu of effectively the appellant saying the judge should not have done what he did. He should have done any one of these 5 different things and wasn't entitled to do what he in fact did. That is, with respect, hardly a promising backdrop upon which to seek to overturn the judge's findings. And in fact, when one looks at the judgment, as my lords did in a little detail during the course of my learned friend's submissions, you can see very clearly why the judge took the approach he did to the comparables, why he decided that the other 2 comparables were not in fact good comparables, in particular by reference to their location. The one additional reference I think I need to give, my lords, is this, and that's that we looked at paragraph 227 to 231 of the judgment, where the judge referred to a finding he had made earlier in his judgment about location.
Sorry, give me the reference again. Paragraph 200 and...
we looked at 227 to 231, or rather my lords did in the learned friend, which is page 121 of the bundle. And in those paragraphs, the learned judge refers to an earlier finding that he's made about location. And I don't think my lords were shown that earlier finding, which is page 118 of the bundle, and it's paragraphs 209 and 210, where he sets out further reasons as to why he was agreeing with the logic of Mr. James and Mr. Buckingham in preference to that of Mr. Fawlts and Mr. Davies, or the views of Mr. Fawlts and Mr. Davies, so far as the location was concerned, and explains in paragraph 209 why the Adderbury sites were not comparable. So it's all there in the judgment, my lords. The only final point as to pick up on this is, as my learned friend very fairly accepted during the course of argument, the point that's now being sought to be advanced was not argued below, and indeed it's very difficult to see how it falls within the claimant's pleaded case at paragraph 27 of the particular claim, which is core bundle tab 12, page 147.
That's ground 7.
That's ground 7.
Yeah, okay, thank you.
My lords, I've taken that at something of a canter, but unless...
That's all right, you're going to let us have a piece of paper with your 5 propositions on.
Thank
you very much, thank you. Mr. Rosenthal, 4:30 is as late as we can get.
My lords, I'm proposing only to reply on ground 2.
Okay.
First of all, to address the point that my Lord Justice Snowden made about the Singer case. In making the submission that I did earlier, that it's not for the expert to give evidence of the size of the bracket, I was seeking to explain the passage that I took the court to in Titan and Collier's, which set out I hesitate to describe it in this way, but the summary of principles of Mr. Justice Blair in that case, where it was said that the court will hear evidence about the level of difficulty or otherwise of the valuation. I accept the point that my lord makes about the Singer case, and I accept that there are other cases where the court has had evidence before it of a range in terms of percentages from the valuers. But the real point we make here on ground 2 is that based on both the evidence that the judge had in the form of Mr. Buckingham's opinion on this issue, and the judge's reasoning, the ultimate conclusion that the judge has come to, that his valuation was outside of the bracket, was an irrational conclusion. It was a conclusion that a judge no judge should have come to, taking all of that into account. And just to summarise, and I'm not going to labour points that I made in my submissions earlier, but just to summarise the reasons that we say that, I'm going to just set out 4 broad points. First of all, in terms of Mr. Buckingham's evidence, as I said earlier, he started from the premise that the bracket would be 20%. And his evidence was that should come down because there's only one comparable in play. And so this is a less difficult valuation than it otherwise would have been, because we've got the golden comparable down the road at Bloxham Road, which informs the value of this site. The judge didn't deal with this, but the starting premise of 20% in my submission runs contrary to the way Mr. Justice Cawson expressed the principles that he did in K.S. Lincoln. Now, my second point, and I made this point, but I rather skipped over it, but it is an important point, is that Mr. Buckingham accepted in cross-examination that this valuation is not exceptional for a valuation of development land. But for your lordship's reference, that is at page 511 in the supplemental bundle behind tab 26, letter B. So he accepted in cross-examination that it's not exceptional so far as development land is concerned. I then, as I said, went on and put to him that in light of that, 15% is too high, and he wasn't having any of that. But given his concession that it's not exceptional, the judge, we say, ought to have questioned the evidence that he ultimately relied on, Mr. Buckingham, that the range should be 15%. Now, my third point is the one that I made earlier about the way the judge actually expressed his reasoning on this point, which is the range for a range. And he accepted that a range of 10% would be entirely appropriate in paragraph 237 of the judgment. And that followed through into the way he then applied the bracket that he had determined to his valuation of the site in paragraph 238. Because the way he put it was, this is page 124 in the core bundle. Although 14.15% is towards the top end of what I have found to be the appropriate bracket, having regard to the above, I can safely conclude that Mr. Jones's valuation is within the margin of error allowable. So the judge is clearly somehow working on the basis of a range of brackets. And that, in my submission, is not the exercise that a judge is required to perform in this part of the analysis. That's the wrong way to go about it. The purpose is to set a fixed upper and lower limit. We get that from the Titan case and the passage I took the court to at the very start of my submissions in legal in general. And then the fourth point, and I accept in light, especially in light of some of the comments that were made during my Line in Friend submissions on this issue, that this isn't a particularly overbearing point, but it is relevant nonetheless, and that this is the judge's reliance in support of his 15% on the Dunfermline case in his reasoning, which in my submission is misplaced. Because the only similarity, the only factual similarity between the two cases is that the court was concerned in Dunfermline with the valuation of a development site, and the court was concerned in this case with the valuation of a development site. And if one looks at the reasoning of the judge in Dunfermline, which is tab 9 in the authorities bundle. It begins at page 397. I'm not going to go through all of that because it is heavily dependent on the facts of that case. But what ultimately struck the judge was the fact that all of the experts in that case, both the valuer whose valuation was being challenged by the claim, and the experts giving evidence to the court on either side, were reliant on residual valuations. There were no comparable transactions to give evidence to the valuer of what the market was doing. And of course, residual valuations are notorious for how dependent they are on the precise inputs. And it was argued against that, well, a lot of the inputs were agreed, so that rationale doesn't really apply here. But ultimately, it was the fact that there were no comparable transactions to guide the valuer that led the judge, in that case, to 15%. So that is not a helpful guide, or it doesn't support, I should say, the judge's ultimate decision to base his bracket on the evidence of 15% that he had heard. So for all of those reasons, we say that this court should interfere with that aspect of the judge's decision. My Lords, without repeating submissions that I made at some length this morning, I don't think it's necessary for me to reply on ground one. I will consider the written document that my learned friend produces, and if it's necessary, I don't treat this as further submissions in writing, but As your Lordship indicated, if it's necessary for me to say anything in response to that, I will do so.
Well, I suggest that Mr. Chapman gives us that by 4 p.m. tomorrow, and you give your answers by 4 p.m. Monday. Good.
And on that basis, my Lords, unless there's anything else I can assist with
No,
today on my submission.
we've achieved 6 minutes. Thank you. Well, thank you both very much. Thanks to your junior, not juniors, and solicitors. Interesting case, and we will take time to consider our judgments, let you have them in the usual way. And when you get them, please only use the draft for the purpose of giving us typographical corrections and agreeing the order and costs, and for no other purpose whatsoever. And any argument as to those matters will be dealt with in writing.
Rise at table.